Hi, I'm Patricia Trainor, Senior Managing Editor at BLR. Yesterday, the United States Supreme Court issued a landmark decision that affects same-sex couples legally married under state law. The court found unconstitutional Section 3 of the Federal Defense of Marriage Act, or DOMA. Section 3 limits recognition of marriage to a legal union between a man and a woman and excludes legally married same-sex couples from the rights and responsibilities available under federal law to opposite-sex married couples. In the case before the court, Edith Windsor and Thea Sire were married in Canada and then lived in New York, which recognizes same-sex marriage. When Spire died, she left her entire estate to Windsor, who was barred from claiming the federal estate tax exemption for surviving spouses because of DOMA. As executor of the estate, Windsor was required to pay federal estate taxes on the property, and she brought suit against the IRS to get a refund. The Second Circuit Court of Appeals upheld a lower court ruling that DOMA is unconstitutional, and the Supreme Court affirmed that decision. In its decision, the court ruled that DOMA violates basic due process and equal protection principles by depriving same-sex couples of the benefits and responsibilities that come with federal recognition of their marriages. The majority opinion by Justice Kennedy found that DOMA's practical effect was to, quote, impose a disadvantage, a separate status, and sow a stigma upon all who enter into same-sex marriages made lawful by the unquestioned authority of the states. Now, for employers, the decision is largely going to affect benefit programs. So, for example, the tax treatment for spousal benefits, like employer-provided health benefits, is now the same for same-sex and opposite-sex couples who are legally married under state law. Under DOMA, an employee with a same-sex spouse was required to report the employer's contribution for the spouse's health benefits as taxable income. In addition, the employee's contribution for the spouse's coverage could only be made as an after-tax contribution instead of a pre-tax contribution. Same-sex married couples who live in states that recognize same-sex marriage will likely be entitled to survivor and consent rights in ERISA plans. What's not clear yet is how the court's decision will affect legally married same-sex couples who live in a state that does not recognize same-sex marriage. The court ruled only on Section 3 of DOMA. Section 2, which allows states to refuse to recognize same-sex marriages performed in other states, was not at issue in the case. So employers should review the definition of spouse in their benefit plans and evaluate their options. Employers will also need to review their leave policies under the Federal Family and Medical Leave Act. In light of the court's decision, an employee may be granted FMLA leave to care for a same-sex spouse. If you count California now, there are 13 states and the District of Columbia that have laws providing legal recognition for same-sex marriage. On the same day of the DOMA decision, the Supreme Court also issued a ruling that will allow California to again issue same-sex marriage licenses in that state. Be sure to check hr.blr.com for more updates and information regarding the implications of the DOMA ruling for employers. Thank you.